As paramedics, we need to be constantly aware that even our best intentions can have a negative outcome. Both for our patients and for our careers, as the decisions we make on the road can have legal and ethical repercussions. Practicing paramedics are required to work within legal guidelines dictated by legal framework and legislation, as well as adhere to the professional and ethical standards of the territory in which they practice. Ethical behaviour for paramedics is practicing in a manner consistent with what society believes are good values. Maxine's justification for stopping adheres to a consequentialist ethical framework, whereby the right action is the action that causes the greatest good for the greatest number. By remaining to treat the passengers in the road traffic crash, Maxine positions herself to provide immediate care to more people.
I went through the intersection quickly as it was a time-critical case and other vehicles should have seen and heard the lights and sirens.
Maxine is referring to Rule 306 in the Transport Operations Regulations that exempt drivers of emergency vehicles from obeying certain rules given the right circumstances.
So I felt the need to stop at the incident as it was the immediate scene to which I was present. I felt that it was better to attend the crash knowing that there was at least one patient, potentially more, that I could provide life-saving care to than the original case, which only had one patient with questionably less chance of survival.
When Maxine became involved in a traffic collision, she had a legal obligation to stop and provide assistance under the Queensland Transport Operations Act of 1995 that requires participants in traffic accidents to provide assistance. As a paramedic, Maxine is able to provide care at a higher standard than other bystanders and therefore has a professional duty of care, as the injury sustained by the driver could not be effectively managed without professional pre-hospital support.
Looking into Maxine's case, there was a requirement to investigate the conditions leading up to the accident and to assess the legal parameters to determine the duty of care, as well as determine whether Maxine was at fault, as proven under Queensland law.
The question is whether Maxine's driving was justified. If we return to the Transport Operations Regulation of 2009 and examine Rule 306, exemptions for drivers of emergency vehicles, the rules state emergency workers are exempted from the provisions of the regulation if the driver is taking reasonable care, it is reasonable that the rules should not apply, and the vehicle is displaying a red flashing light or sounding an alarm. In Maxine's case, it has been established through the statements of her partner Max that she failed to take reasonable care. Maxine did not slow down and use caution when approaching the traffic lights to ensure it was safe to pass through the intersection against the red light. Maxine has not met the criteria of Rule 306 that would provide her with the exemption required to pass through the intersection against a red traffic light. Maxine may be found to be at fault for causing the subsequent collision and may face criminal charges for breaching the regulation. Rules 78 and 79 of the regulation requiring drivers to keep clear of or give way to emergency vehicles does not apply in this case, as the other drivers involved were not given a reasonable amount of time to react to the approaching ambulance due to Maxine's speed approaching the intersection. The Ambulance Service Act of 1991 dictates that ambulance services are required to protect persons from injury or death. While Maxine was unable to protect the driver from injury, she is able to assist in preventing her death. Taking these elements into consideration, Maxine was legally required to stop and provide assistance not only as an ambulance officer, but also as a driver on a Queensland road.
For this, we'll have to assess Maxine's behaviour as well as her actions to rule whether she fell below the standard and could be deemed negligent.
Tragically, the child that Maxine and Max were en route to treat could not be resuscitated by the crew that was redirected to the case due to the delay in arriving on scene.
Maxine should be held liable for my child's death. It was due to her responsibility and dangerous operation of motor vehicle that she was involved in the collision, and therefore emergency health care which could have saved my child's life was delayed.
Ultimately, the question becomes, does Maxine's obligation to stop and provide assistance at the crash site leave her susceptible to a suit of negligence due to the delay of care to the patient at the original call-out? For this, let's look at what constitutes negligence as well as duty of care. Negligence can be defined as the failure to apply reasonable care in order to avoid foreseeable injuries or harm to others, and duty of care can be defined as a requirement that a person acts towards others in a manner that a reasonable person in the circumstances would to avoid reasonably foreseeable harm. In order to uphold a claim of negligence, 4 elements must be proven. The first is duty. Did Maxine have a duty of care to the patient at the original call-out? The second is that there was a breach of that duty of care by proving that the care given fell below the reasonable standard. Thirdly, that the breach resulted in physical, emotional, or pecuniary loss, referred to as harm or damages. And finally, that there is a causal link between the act and the injury by establishing that the harm caused was not too remote from the breach. As Maxine and Max's duty of care to a patient does not commence until they have made direct contact and established a patient-care relationship, it is unlikely that a civil suit of negligence against them would be successful. Even though Maxine may be at fault for causing the accident that led to the delay, it has already been established that Maxine and Max were legally and ethically obliged to stop and provide care at the accident site.
Following the incident involving one of our paramedics, the QAS has developed a number of recommendations to assist our paramedics in returning to the workforce after time away. The QAS upholds a commitment to provide a duty of care to its employees to ensure the highest standard of care can be provided at all times. Our recommendations from this case are to restructure QAS's reintroduction program for paramedics, specifically by incorporating revision driving courses prior to on-road work, paired with counselling for all members, as well as transitions by LARU to ease ambulance officers back into the pre-hospital setting.
By introducing the categorical imperative of a mandatory driver refresher course, it is hoped that this will become an accepted universal law that will improve the overall competence of the service. The staged return to work and compulsory counselling adopts a utilitarianistic approach that will benefit the majority, even if some feel it is unnecessary.